Dated July the 16th, 2018. It's about 8:03. I guess I got a question for the attorney. Is it proper for the chair to sit in for one of the board members, because we only got three, and I'm just asking if it'd be proper for the chair to...
Yes, sir.
All right, well, let's get started then. Thank you, Chairman. Again, welcome. I'm going to call the roll for each and every one that's on the board. That's Commissioner Stan Norton, Commissioner Nate Jackson here, Commissioner Galvin, here. Commissioner Chairman Roberts. I see we have our Commissioner Joe Clayton, and we got Commissioner Ian Levy, and I see some other commissioners in the audience, but they're not sitting on the board. But good morning, and to the staff, Director Shaw, Attorney Page, Staff Gilliam. I see Barry Whitson was back here somewhere. Also, we got Attorney Elizabeth Goldstein, and we got Selena Brown, attorney. And then we also got Robbins. Yeah. Hi, Robin. And with that said and done, I thought I saw Bob Weaver somewhere. Good morning, Bob. And I thought I saw Vaughn. I guess she stepped out. I don't know the other two. The lady and the gentleman there, would you share with us your name?
I'm Jared Stanford, now paralegal.
Welcome.
Hi, my name is Ashley Gino. I'm an assistant general.
Got some heavyweight this morning, Chairman. All right, with that said and done, I think Attorney Page, we're going to turn the meeting over to you at this point.
Excuse me, board members, if possible, since Attorney Robin Ryan is here, if we could begin with number 126 on the legal report. She has another board meeting this morning, and if you had any questions for her for the last three cases in the legal report, she's here and available to answer those questions. So if you wouldn't mind beginning with number 126.
6. Okay. Case number 126. Does any commissioner have any comment?
Well, I don't have anything specifically on 126, but as I was reading some of these that we closed and flagged that were assessed civil penalties for obviously law violations, and my question is, when we do something like that, whether they disappear or whether we close and flag for whatever reason, when those penalties were assessed, I mean, do they just go away? Do we not try to collect those? I mean, because the ones that I saw were not necessarily anything other than the person's gone missing.
Well, when you assess a civil penalty, you cannot collect that civil penalty unless and until the respondent agrees to the terms of consent order. And if they agree to the terms of the consent order and sign a document, then, of course, if something happens in the future, you can still collect on it. What happens when you do a civil penalty and it's not agreed on or terms are never reached, it then goes into litigation. That's the status of the cases you have with me this morning. So that there is no penalty pending because there's no agreement. And the reason I'm bringing some of these back is because if I were to go forward in litigation, I can't get the person or persons or business or whatever because they're not there. And the recommendation for closing and flagging is that if somehow in the future another complaint comes in against this same entity or person, we can bring back what we had in the past and use it to assess and review the newer complaint.
Okay. Thank you. I understand.
Mm-hmm.
In your case, with 126, 127, and 128?
That's correct.
Okay. So anyone got any comments on 127? Okay. Hearing 128. Any comments on 128?
Just one comment, and I brought this up in the last meeting on the open title penalty assessment. It's pretty standard. It's $500, and sometimes I see $100, and I think we explained that last time. I just saw it again on this. Can the staff clear that up?
On number, which number?
It's the last one, 128, I
Okay.
guess.
The,
It just announced that there was $100 for the open tile, but my understanding is 500, not 100, and we talked about that.
I did not present it.
Okay.
Initially, so I don't know. I don't know what your discussion was.
Okay.
Is that but after the discussion, these were the terms that were
Right.
presented to the respondent.
Just a comment, because we'd had a discussion previously that the civil penalty for an open tile is $500, and just making a note.
And any more question? I think we are finished with,
Finish with me?
unless you got some more that I
No,
don't know
no.
about. Okay.
Thank you all, gentlemen. I really appreciate it because I've got to go to another board meeting, and I hope they're as good as you were. Thank you.
Thank you. Okay. Okay, we're ready to get into the report, the additional report. Do we have any comments from one? I know I got some question about on page 3160. Do you have anybody have anyone before we get to that? Okay.
Know me by now.
Okay, Commissioner Norton.
Thank you. On page 8 of 60, item number 14, one of our responsibilities as a commission is to empower the consumer. And my question with this, like the complainant learned that her vehicle had previously had a salvage title in another state, but the respondent claimed that the auto check did not illustrate a branded title, just showed 2 accidents, and the respondent is attempting to work with the complainant. This is the recommendation is closed, but my question was, how did the consumer know that there was evidence to prove there was a branded title in a previous state? And
So this is this
Okay.
comes up quite often. A lot of our consumers the complaint will say, well, I found out it had a salvage title. And then when you look at it, it's actually not a salvage title. I'm not 100% sure where the consumers pick that language up, perhaps at the county clerk level. But
Right.
what ends up happening is we look, and what they mean is there's an accident in the history. And so we'll pull it, and then the dealer's got to kind of try to reconcile
Right.
what they found. So there was an accident history here, and the complainant was sure that it meant the title should have been branded in some way, but not in this case.
Also on item 19, on page 11 of 60, this is the case where they had the $90,000 civil penalty, and this is, I think, the dealer in Memphis. This has been a pretty bad situation. And could you get the staff give us an update on what's going on there?
Absolutely. At this point, the Attorney General has agreed with the board's motion to proceed on an injunction. Legal staff has been working with our new law clerk in order to get together a comprehensive packet of every complaint we've had, all of the licensing history for these folks, in the absence of, really, and all of the news media that we have access to. Our law clerk is amazing. We have for this summer. Her name is Marissa Cobb. She's put together an excellent document, an Excel document that walks through each injured consumer, how they were injured, the contact information, all of that. So as soon as we have that done, we're going to put it together on a disc, get it with the Attorney General's office for their review, and they'll start that process of seeking an injunction in Chancery Court, contacting our complainants to see if they can serve as witnesses, working with our internal investigation team. So it's exciting. It's taking a little bit to get all of the documents together, but it was wonderful to see that the Attorney General's office was supporting this commission. I did have some bad news. The prosecutors in Memphis ultimately decided to dismiss the case that they had on the criminal level due to, I think Paula can speak a little better to it, but sometimes we struggle with prosecutors understanding the complexity of what we do. A lot of those criminal violations are in the paperwork, and it's just not something that they're interested in or that is easy for them to grasp, and so a lot of the times our criminal actions don't make it as far as we would like. And so I think that speaks volumes to this commission that we're going to be able to be the ones that step forward and make it clear what's happening here and why it's problematic, and hopefully see action. So, while it's a terrible thing that happened there, I think it reflects well on this body that we are able to continue forward despite that.
Appreciate the update. That appears to be a pretty big problem in Memphis, and I hear on the ground down there some of the stuff going on, and they're in a position to harm a lot of consumers, and they feel like they're above the law. So I'm glad to see something done. Thank you. See, item 47 on page 24.
Can we backtrack before
Yes,
that?
yes, please.
Can we go to page 13 of 60 on number 24? I'm just curious how we came up with the civil penalty of $5,000 for a advertising mislead price. I'm just, to me, I think that's a little steep, because I got two controversial ones on 27 and 38. I'm just curious to see why they're different. But let's talk about 24 first. I mean,
For 24, we went to 5,000 because this would be a third-time violation, and so for the same exact issue. So each step we've gone from 500 to 1,000, and then I jumped it all the way to the max penalty. I'm definitely open to any ideas if you'd like to adjust that down, but I figure third strike at this point, it was worth to go to the top to kind of make it clear that you need to get this in line. We also had a $2,000 penalty in 2016 related to also an advertising violation, not this directly, but rather listing vehicles incorrectly on eBay and then not honoring the deals after it was discovered the pricing was wrong. And so really this is in many ways a fourth time advertising violation.
So are we saying the first offense is usually around $500?
It can be based on the scale. Sometimes that can be per advertisement. It can be, and we sometimes will have an aggravating factor if a consumer was actually misled or things like that. So the advertising violation one can be because of the scope of potential, whether that's one wrong listing or mailers that went out to the entire state, that penalty can vary quite a bit in that category of what we would recommend.
Okay, so when I look at page 15 of 60 on 27, a civil penalty of $3,000, $1,000 for a lack of conspicuous terms and disclosure. So saying that this is a more than one defense, as far as it could have been a 500, but you went ahead and bumped it up to 1,000 because it was more than one.
Also because they also have a pretty extensive history with us. While they're not directly advertising, the recent letter of warning we did for them was for false, fraudulent, deceptive acts. And in many ways, our advertising violations are false, fraudulent, deceptive acts. So for that reason, I thought it was time to to recommend to this commission to make a stronger statement to this dealer.
What I'm saying, so we're on a consistent basis then, aren't we?
That's the
Okay.
goal, absolutely,
Okay,
absolutely.
that's all I got.
Commissioner Galvin, did you have a question about number 27 as well? My question on 27 is the rules regarding the disclaimers in the radio ads. I mean, this one indicates that it was extreme. What is the standard that we're using to determine whether the requirements for the disclaimers?
Sure. So what our rules require reflects the federal regulations, which is that the disclaimers need to be clear and conspicuous. I think that sounds weightier than really what it is. In the law, clear and conspicuous doesn't mean it's bold and huge. It can be small and at the bottom, but a consumer needs to be able to read it, understand it, and it needs to be available to them. And so in the context of this radio ad, when you listen to the advertisement, I mean, you can't hear anything, and it seems purposeful to the point where if we tried to slow it down, and you still cannot at all understand that there is a disclaimer being issued at the bottom. And so because of that, even though I think clear, conspicuous, while those words sound very weighty, legally it's a fairly low bar. I still think this even fell below the legal bar. So that's what we're looking for, is that clear, conspicuous language.
There's not a standard, if an advertisement uses the set-up language that you do here at the end that we're used to all hearing, as long as you can still make it out and understand.
Correct. Yes, that's right. So it can be. They could do it fast, but playing the music over it and having it, or even reducing the speed to 2 times slow and not being able to ascertain it, I think doesn't meet the standard.
At page 2460, item 47, this particular situation, there's a letter of warning issued, and because the taxes were not collected on the front. Apparently, it's a Tennessee dealer, and of course, the Tennessee dealer is required to collect taxes, and it's in the deal when the deal is originated and closed. And I just needed some explanation on that. Also, who has the vehicle in this case, and also if it failed emissions. If the statute says if a car is registered in a municipality where there's required emissions test, the dealer is responsible for fulfilling that need. So, do you have any update on that? Just curiosity on this one.
Yes. So I just want to make sure I understand. There's two questions. So the first one that you had, Commissioner Norton, was related to the
Sales
sales
tax,
tax.
yeah.
This dealer seemed to not understand how the sales. This is a new licensee, someone that we've been working to get licensed. So I was actually glad to see that there was a license, but it seems to be a general misunderstanding of how the sales tax needs to be done. This person, if you look at the deal on this one, they paid the down payment, and then the rest of the remaining balance was financed out traditionally through your typical plan. And so now they're asking this consumer to give them the sales tax in addition, and they think that they're helping because the woman said that she couldn't pay it, and so they said, "Oh, don't worry, we'll pay it over the next 2 months." They don't seem to understand that no, that down payment or whatever money they got, that's where your sales tax comes from, or any money you have. You're collecting it eventually, but your responsibility as the dealer is to pay it first. That's the top priority. And so they just seem to have a misunderstanding of how that works. And you can see in the emails where they're even trying to work with the consumer, thinking that they're the good guys. It's clearly just they don't understand the process. So that's why I was hoping to just inform this dealer, since they're new, of how that works, and hopefully that would resolve it. And perhaps we could even refer it to revenue to make sure everyone else is resolved in that case. It's up to us on that one. As far as the emissions testing, that is actually a little less clear. We've run into that question before on what's the dealer's responsibility on emissions, and it can depend. And Commissioner Norton, maybe even after, if you know of a statute that requires the emissions, I would love that, because I think we've struggled to find that exact language before.
I've read it. It's in a statute.
There's actually a rule that provides for the consumer to request a copy of the emissions, to request that an emissions test be conducted prior to the sale. And that's where the tricky part comes in, is that it's prior. If they don't request it prior to the sale, then it gets complicated when after the purchase, they've purchased it and then find out that it will not go through the emissions process.
I'd like to read that again to interpret that, because we run into that quite often. All right. Did anybody else have number 48 on the one about the vehicles coming from Houston, Texas, the floods? The big one. Yeah, that's my question on this is,
Page is that,
it's on page 25 of 60, item number 48. And the recommendation is to authorize a civil penalty in the amount of $5,000 for unlicensed sales activity, and a civil penalty in the amount of $5,000 for allowing the unlicensed flea market to act as unlicensed salesperson in off-site sales. To me, that's the least of the problem. The problem is how many cars do we have here in our state that are not branded as flood cars, and what do we have anything regarding that?
Yes, so this is ongoing. At this point, we've counted 32 vehicles came over. We've accounted for all vehicles. We've located them. We have paperwork. We know which consumers have them if they were purchased. The silver lining of this whole ordeal, honestly, has been the dealer made a very explicit and very detailed disclosure to these consumers about the ambiguity in the titling process. We are working with the state of Texas. They are currently investigating their dealer. Where we're at is what we understand happened was the dealer in Texas did disclose all of the inventory, went through its normal insurance process, and the insurance adjuster requested the documents be provided to them open. Because of that, we have initiated an investigation with our insurance team. It seems Texas, and I think internally here, we're looking at the insurance companies involved as likely the more significant bad actors in this case. They seem to have taken advantage of the dealer not understanding the process of what to do, and quite a traumatic experience, if you can understand. Texas is going to discipline its dealer for producing those documents open, but they are too more focused on the insurance company. Texas has informed us the insurance companies involved, actually, they've heard of them doing this before. So we are looking more right now into who involved at the insurance level did this, and does that qualify for discipline against their insurance license. And so that's where we're at as far as probably maybe the more hefty discipline that will come out of this case. These folks here, the flea market is a salvage flea market. What they do is purchase farm equipment, anything that would have been damaged in any sort of storm. And this kind of, the insurance company brought this to them as a subcontractor and asked them to dispose of the property. They went to the county clerk, and that's when the county clerk informed them, oh, you can't sell these, you're not a dealer, and they didn't, and that's all they knew. So then they went out and tried to find anybody who would work as their dealer. It seems, while they shouldn't have done this, it seems that they all kind of ended up with this inventory and an opportunity and didn't understand fully what was required in Tennessee for vehicle sales. I don't think they traditionally deal in vehicle sales. Usually it's other damaged property. But the dealer should have known. Obviously, they were sure, they understood the problem by producing a very well-written disclosure. But every consumer that did purchase a vehicle did sign a disclosure explaining, Texas didn't brand these titles. We don't really have a process here for this, but these could have been involved in significant water damage. This is the deal. This is why you're getting 50% off of a new vehicle, and that the ambiguity is on you, and it really does lay it all out. Obviously, it's still problematic, but Texas at this point can't even tell us whether they would have branded those titles. They're still trying to figure that out.
So we don't know if these titles should be branded. In my opinion, they should be branded. Obviously, there's a breakdown somewhere between Texas and Tennessee where these things need to be branded.
Yes, so Texas is currently trying to figure out whether the vehicles, using the inventory list and the pictures and everything else that they had from the actual flood and the insurance claim, ascertaining whether under their standard for flood, whether the vehicles at that point should have been titled. Everyone agrees, obviously, the insurance company should have titled the vehicles in their name at that level, so there's at least that failure exists. What those titles would have said under Texas law, Texas is still investigating currently.
Well, if there's evidence that these were paid as a total loss, does Tennessee not still stand responsibility to brand the titles if there's a total loss?
It would depend on Texas. So Texas had the vehicles. They were in Texas. They would have been the state to deal with it, and I'm not familiar with what standard they would have used in this scenario. And they actually aren't sure either yet, so since they're still trying to look into all the facts. But when they do let me know, I'm happy to update the commission on what should have happened. And if we need to come back and adjust this, if we end up finding out through Texas that more than just this occurred, whether maybe Tennessee played a bigger role. At this point, it doesn't seem to be. It seemed more that they just landed here through the insurance company trying to, I don't want to make an assumption. We're not done investigating, but you can clearly understand trying to get more value out of these vehicles than they would have had if they had titled them properly. So at this point, we can't say whether they should have been titled under the title should have been branded under Texas law, and then that would have depended on how they would have been addressed in Tennessee.
Unfortunately, this is the tip of the iceberg because there's only 32 cars that we know of. I mean, there's Zurich pulled out of the property and casualty business because they suffered heavy losses. There's thousands and thousands and thousands of cars that are out there just like this, and so to protect the consumer, I mean, these 32 cars are going to enter in, and with no brand, they're going to stay in the market, and they're going to create problems forever because once you submerge these vehicles in water, they're not going to last. They're going to deteriorate. So, I mean, I just think it's something we need to take a look at, and I appreciate it. It sounds like you are, but when I see something like this in our industry, it's horrendous. When we deal with this, we go to auction, we trade these vehicles in, and it just creates a huge problem. And we knew this was going to happen when the flooding occurred in Houston. So.
Right. We've been thankful that this is really our first most clear example of it, but you're dead on right. It set off some, we've obviously, Paula and her staff have worked immensely with our media team to put out information about flood cars to consumers. But you're right. One of the things we try to explain to the dealer in this case is it's great that you did a disclosure, but that disclosure is not going to be reflected in a vehicle history in subsequent consumers, right? So they won't see that document. But we're very thankful to be working closely with Texas. They've been absolutely spectacular. Paula put us in connection directly with them through her connections, and I'm thankful to have their assistance. And I think if anything were to come up in the future, we've developed a pretty good relationship with them, and so we'll try to keep an eye on it.
Would it be possible to get an update from the staff outside this hearing, that we can stay informed of what's going on here?
We'll actually have to bring it back to the full committee on any reports that involves a legal action. And I think it's fair to state this is a multi-pronged investigation, so you're likely to have multiple individuals result in some form of fine or penalty. This is just the first one that you're seeing. And in my years in dealing with salvage vehicles, which is nowhere near what you gentlemen have experience at, but this is probably one of the most clear examples of circumventing state title laws that I have ever seen. So I fully anticipate that you'll see additional penalties going forward of other individuals that have been involved at a different level.
Chairman Robbins.
Does the narrative say, or has it been said, the location of the flea market, Tennessee or Texas?
It is in Tennessee. So the flea market, the vehicles were located, we got a complaint. The complaint came from an association. We're very thankful for them. They had heard wind that there was a flea market selling these vehicles out of just in the back. The way that it looks like they set it up is they did have them in the back. They weren't advertising them. If a consumer would come by and inquire, they would then put them in contact with the dealer, and the dealer would process the paperwork for the sale and ultimately own the vehicles, then sell them, is how it kind of set up. So they had heard wind of this from folks in the community. Obviously, I think a dealer sees clearly, same model, they look brand new. My investigative team said you couldn't even, if you open the doors, you really couldn't tell at all that there had ever been water, no smell, nothing. They just look like a whole bunch of really nice brand new cars right there in a line at the back of this flea market.
Is that West Tennessee?
Yeah.
I know where it is. I heard the same thing in the streets. People are asking. We actually bought that property. People were calling you already got cars out there. We said, no, I was wondering whose cars those were. Yeah.
The issue as to whether or not the commission has any authority in dealing with the insurance company. I'm looking at the statement here, and I'm looking for it. Then I'd like to read it back. Yes, this is the flea market stated that an insurance company had subcontracted with it to sell the vehicles. Well, that flea market is in Tennessee, and the insurance company has subcontracted the sale of these vehicles. I don't see why that wouldn't put it under our venue for a violation of our
That is one of the issues you may see me bring back. Right now, we have not been able to confirm that relationship. This is just word from the flea market on the street. So we are working intensely with Texas to actually get the insurance company to respond to us. That's the portion right there, is that line of what we know and what we haven't confirmed. So it may be that we bring it back in that context, or work with insurance to see who has the most teeth, the easiest way to really make an impact on making sure this doesn't happen again. But you hit the nail on the head, Chairman Roberts. That's exactly the line we're looking at right now.
With that statement, if it's found if our investigation can affirm that this insurance company was involved in the sale of these vehicles, I would sure like to see them.
Absolutely.
I was short on time, but I just got a couple more before we get to.
What page you got?
I'm on page 32. I think you got 31.
I got 31.
Okay, go ahead. Yeah, go ahead.
Page 31. 64 and 65. This was according to the report, a finance company was selling these trucks for the past 18 months for incidental to.
Yes, sir. Under the statute, a financing company is explicitly stated as being exempt if they're selling the vehicles incidental situation. They are exempt. And these are large commercial trucks.
I'm going to challenge that. I mean, I don't see. I think finance companies can sell at at auction. I don't think they can. I don't think they can sell to the public.
I would be happy to pull the statute. I don't have my statute book with me, but I'm happy to address that.
Okay. It looked odd for all of us as dealers to see something like that. It's kind of like a lease company. A lease company can sell at auction, but
the statute specifically states that
it does.
They
Okay.
don't have to be licensed.
Okay, I'll learn today. I'd like to see it though, for curiosity. I'm going to trust but verify. Thank you.
Commissioner Norton, you had another one?
Let's see. Yeah, I did. There's small ones, but one is on page 32 of 60, item number 66, that we fined the dealer $500 for false, fraudulent, deceptive acts related to processing a title. And it was a situation where a son gave an out-of-state address to be titled. My question was what was the address given at the point of sale here in the state of Tennessee? Was it a Tennessee address originally, or was it always an out-of-state address?
It was always an
Okay.
out-of-state address.
Fine, that clears that up, because it wasn't clear, and I want to make sure, because that does happen. We have consumers buy a vehicle, and a month later, they don't title the car, they move, and they want to go back and redo the paperwork, and that's just a courtesy from the dealer. So I didn't know if that's the case here, but since there was a fine involved. Thank you. Last one I have is on page 3460, item number 71. I don't know, just some explanation on this. It was just a very short narrative about selling vehicles and paying sales tax and floating titles. I didn't understand the verbiage of floating titles, and the respondent claims to be disabled and sells vehicles to supplement his income. Didn't see the relevance there, but is there an explanation on that case that could clear up maybe anything about it? I was kind of lost in this one.
Mainly the response from the respondent was what was lacking, and this individual was very flippant about the whole situation and said that they were disabled and that's why they were doing this, that they needed additional income. They weren't able to manage without doing this, and they really didn't think it was a big deal. So that was the main issue. I was not clear on the floating titles, but that was what was stated in the complaint. So in light of that, I am recommending that a formal hearing, civil penalty.
Okay.
We don't have any history on this particular respondent, but I'm seeking $1,000 for the unlicensed motor vehicles. It was mainly the response that was the problem.
Okay. Thank you. I just thought it was vague. I just needed a little more elaboration on it. That's all I've got.
So do we know the actual definition of a floating title?
We have no information about. I don't even think that this respondent understands. Yeah.
Sound interesting. Floating tile.
Sometimes we've used that just to say that
Skip
someone
title.
skip
Open
title.
title.
Open title.
Or,
Yeah.
or
Okay.
That's what
titling,
you're-
not paying off your floor plan, or sometimes like colloquially in the office, we'll say they're floating titles. When they're passing titles out they don't actually own yet.
Or maybe a Houston
Basically,
title.
their name's not on the title in some way, and they can't establish ownership.
I think that's all the committee has. I don't think we have any more questions. Chairman Roberts, you have any more? Okay. Commissioner Levy, you have? That being said, unless the staff has some additional, oh, you had one additional. Where is that? What did I do with it?
Sorry. There was a supplement with one case that was being represented to you, and that was 2017061881. This respondent is making every effort to become licensed, and in light of that mitigating circumstance, I am recommending that the civil penalty be reduced to $250.
Commissioner Jackson, only one question. Is that we're dealing with a dismantled recycler? Is that what we normally, the $250, is that the normal standard if we find someone that's a dismantled?
It's $1,000, but because they are making every effort and cooperating with the Motor Vehicle Commission staff in getting licensed, we felt that it would be best to.
How is normal, the standard?
Yes, sir.
I just want to make sure about the $250 versus, the $1,000. Okay. Any comments on that? Okay. Well, with that said and done, do we need to make a motion to adopt the report as been presented, and do we do it in the next meeting?
I believe that you would make that recommendation at the full commission meeting.
With that said and done, do I have a motion to adjourn?
Sure.
Have a second?
Second.
All those in favor of the motion, signify by saying aye.
Aye.
Any opposed? Ayes have it, so ordered. Thank you so very much.
Thank you.
Thank you, Chairman Jackson. The full commission meeting will convene in about 10 minutes. That would the regularly scheduled meeting of July 16, 2018. It's 9:15 a.m. Director Shaw, would you call the roll, please?
Chairman Roberts.
Here.
Commissioner Lee.
Here.
Commissioner Galvin.
Here.
Commissioner Clayton.
Here.
Commissioner Fox.
Here.
Commissioner Kramer. Commissioner Jackson.
Here.
Commissioner Melton. Commissioner Murray.
Here.
Commissioner Norton.
Here.
Commissioner Vaughn. Here. Commissioner Tomaso.
Here.
Commissioner Levy.
Here.
Commissioner White.
Here.
Commissioner Evans.
Here.
Commissioner Barker.
Here.
Commissioner Chibanian.
Here.
Mr. Chairman, we have a quorum.
I would like to welcome Commissioner John Chibani to the Tennessee Motor Vehicle Commission. We're glad to have you, and we're lots of experienced people that are glad to explain anything that comes on staff is terrific. Would you like to tell us where you're from? And
yeah, absolutely. Just a quick little bit about me. So John Chibanian, I was actually born in Washington, D.C., but moved to Knoxville at a young age and was there through college. And an odd turn of events ended up bringing me to Nashville, actually, to work with Governor Haslam at the Capitol. And now live here in Nashville since 2011 and have just had a personal interest in the motor vehicle business for a very long time. So that's it. Yeah, glad to be here.
Thank you and welcome.
Thank you.
Director Shaw, the meeting notice was posted.
Meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission website, included as part of this year's meeting calendar since July 24, 2017. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission's website since July 11, 2018. This meeting has also been noticed on the tn.gov website.
Would you please examine the proposed agenda for today and see if there are any changes desired, recommended, or would we like to approve it and get started?
Jackson, motion to adopt the agenda.
Commissioner Vaughn, second.
Commissioner Jackson moves to adopt the agenda, seconded by Commissioner Barker, I believe. Those in favor of the motion, say aye.
Aye.
Those opposed, say nay. Motion carries. If you'd look at the minutes from the April 23rd, 2018 quarterly commission meeting, and we're looking for any recommended changes or approval of those minutes.
I have one change, Commissioner. Listed in the present and absent, I do list under both. I'm pretty sure I was absent, but I'd like to confirm that I was not here. I do not appear to have voted on anything, so I think it is correct that I remain in the absent column.
Sorry about that.
Make a motion we approve minutes.
Second.
Okay, a motion by Commissioner Barker to approve the minutes with the change.
With the change,
With
correct.
the change. Seconded by Commissioner Fox. Okay, the motion is to approve to adopt the minutes with the change of the attendance marker. All those in favor of the motion say aye.
Aye.
Those opposed, nay. Motion carries. Are we ready to move for appeals?
Yes, Mr. Chairman. We are.
Mr.
This is a
Chairman.
salesperson's appeal, Kevin Ortiz, Chuck Hutton, Chevrolet, Memphis, Tennessee.
And Mr. Chairman, if I could give a brief overview of our new law that's taking effect and how we're going to analyze the appeals before we discuss the appeal with the candidate, if that's okay with you.
For this candidate appeals.
Yes, sir.
Okay.
As we discussed at the last meeting, the Fresh Start Act was recently implemented and is going to affect how we do our licensing appeals. I'm going to read a little bit from our Deputy General Counsel, a quick primer on the Fresh Start Act and how it affects this commission. The Fresh Start Act requires all licensing authorities that are not excluded in the Act, prior to denying an application for a license, certificate, or registration on the basis of a criminal conviction, to first make a determination that the criminal conviction directly relates to the applicable occupation, profession, business, or trade, even if the authorizing statute states that the board, commission, or assistant commissioner has the authority to deny, suspend, revoke, or refuse to issue a license. So as you're familiar, our statute has a section on moral turpitude, and we also have a section exempting people whose conviction where the jail time has ended past 5 years. So what the change you're going to see here is if the applicant has a moral turpitude, does not have a moral turpitude conviction, or it has been past 5 years, we will approve them as we have before. But now if they have a moral turpitude conviction and it hasn't been past 5 years since their completion of their jail or probation time, we then have to turn to the Fresh Start analysis, which will be as follows. The Commission will have to make a justification that demonstrates the following factors were considered before a denial takes place. Those factors are the nature and seriousness of the crime for which the individual was convicted, the length of time since the commission of the crime, the relationship between the nature of the crime and the purposes of regulating the occupation, profession, business, or trade for which the license, certificate, or registration is sought, the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the occupation, profession, business, or trade, any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of the crime to the occupation, profession, business, or trade, and any applicable federal laws regarding an individual's participation in the occupation, profession, business, or trade. Now, you'll probably notice a lot of those factors sound familiar to the questions that the Commission typically always asks anyways during our appeal process, but now we will, legal will be making sure that each of those factors is specifically acknowledged on the record in your determination. So pretty similar to what we were doing before, but we're just streamlining it to make sure we're in line with the new statute.
Questions from the Commission regarding the Fresh Start analysis program? That's a law, a statute now.
Yes, sir. That was effective July 1st.
So I should call it the Fresh Start statute. Is that
the Fresh Start Act?
Act.
Yes. And you should see, they've got a copy of the memo, right, from Mr. Ortiz? You should see in the memo from Mr. Ortiz, you should see it looks a little different than my previous memos, and you'll notice I've gone through each of the factors in my own analysis. And today, when you listen to the appeal, the Commission, as you've done in the past, you can ask questions and you can weigh these factors based on what you hear today. So you don't have, my analysis is giving you what you are allowed to do under the law, but you can look at these factors yourself, and if you decide, we don't think this first factor, after hearing his testimony today, we don't think this first factor really weighs as much as legal wrote before, we're going to reconsider this factor, and you can vote to adopt a different determination today. But you just need to make sure you note your analysis of each factor on the record.
Copy of...
I think if it's laid out like this, that's enough.
Okay. Well, a couple of comments. I'm proud of the fact that the commission has been proactive in asking the questions that the state felt was important enough to turn into an act. So I think that we were questions and the lines of questionings that we made. The second comment is the net result of this for the commission is we'll have fewer appeals. For today, but we'll have fewer going forward. Is that the assumption?
That's correct. There's not any, we think that's correct. There's not any data on that just yet since the act is new and we're just now starting this new process. But under the new act, a lot of the drug convictions that we used to see appeal come before the commission, a lot of those don't fall within the Fresh Start as far as us being able to still deny the applicant because a lot of the drug charges don't directly relate to being a motor vehicle salesman. So I think we'll see a decline in the number of appeals that come before the commission. But I can't guarantee that, of course. Just depends on what convictions come into us on the applications.
Same applies to a dealer as a salesperson. Dealer's appeal as a salesperson's appeal? The same
That's
apply?
correct. We changed that rule, I believe, last year. So if the dealer has 5% or more ownership, they'll be analyzed under this same act. So they would come in and appeal just as the salesperson would come in and appeal.
Analysis is the same, basically, for a dealer app appeal and a salesperson's
Yes,
app
sir,
appeal.
that's correct.
No questions? Then we'll move into the salesperson's appeals and dealer appeals. Mr. Ortiz, are you in the audience, Mr. Ortiz? Mr. Ortiz? Communication from Mr. Ortiz as to request for, what do you call it? Moment.
I'll check the hallway.
Continuation is the word. There we go, continuation.
Okay. At this point, it doesn't appear that he's here, and I don't think anyone has had any communication. If he does appear later, we'll move it down the agenda and pick up at that time.
I would recommend to the commission, I know typically when people don't show up, you vote to adopt what was written in the memo, but since we're moving forward with implementing the new statute at this meeting, if we could table it just to see if he does show up during the remainder of the meeting. That's, of course, just my recommendation to you.
We could do that. Of course, he can appeal. There's an unlimited number of
He can also appeal to Chancery Court.
If we uphold the denial today, he can appeal that.
Yes, sir. He can appeal to court. Yes. It's up to you guys. That was just my suggestion.
A little something to discuss. Continuation has been recommended, but we also can continue to discuss the denial, and should the denial be upheld, the applicant can still
Chairman Roberts, this
appeal.
Commissioner
Yes, sir.
Jackson, I got a question. With the new Fresh Start Act, if someone like this gentleman didn't show, are we required to take that Fresh Act and apply to, even though they don't show, are we required to do the Fresh Act to look at it?
So I've already done that for you in the memo. So
Okay.
you could vote to adopt what is written in the memo where I've gone through each step and analyzed it. Or if the commission would like to discuss any of those elements, if anyone has a different motion, like say a few of you would like to approve this license, we would need to discuss all of the elements. If you want to uphold the denial at this point, he still has an opportunity to appeal your decision, but you're welcome to discuss the factors. But I've gone through and analyzed each one of them for you today with the commission's rights under the statutes. And my recommendation at the bottom says, based on the analysis provided above, it's my opinion that the commission likely does have the discretion to deny such applicant based on his conviction of moral turpitude under the analysis as required by the Fresh Start Act.
If we do nothing and continue it, he's still denied currently, right?
He's been
Is that
given
correct?
notice that the commission has the intent to deny him his license, and I believe he still has time to appeal the decision if you still uphold the denial today.
That being said, Commissioner Jackson motion that we
And the staff recommendation is to deny? Okay.
reason being is that he or she is not here. I guess it's a he. Questions.
Action seconded by, I heard a second somewhere, Commissioner Clayton.
Alvin. Oh, sorry.
A comment on that motion, and anyone else wants to make one. I think it's wise for us to uphold the denial as we traditionally have done. I think we enter into debate and discussion if we pick and choose who to uphold the denial for in the case of an absence or comments on the motion. Okay. Hearing no comments, the chair calls for a roll call vote on the motion to uphold the staff denial. Yes will be to uphold the denial, of course, and no will be to not. Oh.
Commissioner Levy? Yes. Commissioner Clayton?
Yes.
Commissioner White?
Yes.
Commissioner Murray?
Yes.
Commissioner Chobanian?
Yes.
Commissioner Lee?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
Yes.
Commissioner Norton?
Yes.
Commissioner Vaughn?
Yes.
Commissioner Jackson?
Yes.
Commissioner Evans?
Yes.
Commissioner Tomaso?
Yes.
Chairman Roberts?
Yes.
Motion carries.
Motion carries. Thank you. No other appeals on the agenda. Then we can move to the director's report. Ms. Shaw.
Thank you, Mr. Chairman. Since the last commission meeting in April 2018, the following activity has occurred. Dealers opened or relocated during the last quarter, 81. Active licensees as of July 10, 2018, dealers, 3,777. Applications in process, 44. Distributors and manufacturers, 135. Auctions, 29. Representatives, 596. Salespersons, 17,009. Dismantlers, 261. RV dealers, 38. RV manufacturers, 72. Note with no show permits being issued during that time. On the complaint report, open complaints from April, June 2018, number of complaints opened, 172. Number of complaints closed, 226. Annual sales reporting, vehicles reported sold in 2017 of 1,386,221. Recreational vehicles reported sold in 2017, 8,385. Total annual sales reports collected online, 3,334, which I think speaks volumes for the online system when we have 3,777 dealers. Of those, 3,334 reported online. So I think that's a major accomplishment. Late annual sales reports collected, 937, with the total collections on penalties for late reporting, 93,700. Performance metrics taken from the June CFG report, which is customer-focused government. Average number of days to license at 3.69, which we're very proud of. Productivity factor at 139.8%. The CFG goal, we're at 196%. Compliance is at 91.35% as of June 2018. Motor Vehicle Commission customer satisfaction rating from January 2018 until April 2018, quarterly satisfaction rating is at 99.1%. Disciplinary action, April 2018 to May 2018, the total collected, to be collected, $26,750. Online adoption across all professions, that does include manufacturers, auto auctions, dismantler recyclers, salespersons, all licensing types, is 74.65% of all of the new 1010 transactions, which is a person who's applying for a license the first time. That's the type of transaction that makes a difference of when a person gets to go to work. So that's why we measure the 1010 transaction. The fiscal information, as of May 2018, the Motor Vehicle Commission had a $155,316 deficit for the fiscal year 2017 and 18. The year-end close is not until June 30th, and so those numbers are pending. The outreach, one of the major focuses of the Department of the Commission is to reach different areas of the population to help prevent frauds and impositions against the consuming public. I'm involved at a number of levels at the federal level, which I'm continuing to work with the motor vehicle administrators on the Internet Vehicle Sales Working Group, developing the best practices for that group. I am also working with the Independent Dealers Association, who I've decided they're going to keep me busy because I had an opportunity to speak at Manheim Auto Auction. So what the Independent Dealers Auto Association is doing is partnering with the auto auctions who are hosting the events, and we are going into the auto auctions and meeting and speaking to the dealers, informing them on new rules and requirements, and just interacting with the dealers. So the first event was at Manheim. I also have events scheduled in Chattanooga, one in Knoxville, one in Memphis, and I'm also scheduled to meet with the county clerks in August. So so I'm going to be on the road quite a bit in the next month or two, which is great. Additionally, in an attempt to reach the high-risk consumers, I have been able to work with the FTC to obtain some pamphlets and information, both in English and Spanish, that can be disseminated to the consuming public, some very good informational videos and pamphlets, and we're working with the field team to distribute those across all the counties to the 95 county clerks so that information will be available in the county clerk offices. And in addition to that, I have also worked with some of my colleagues in Department of Corrections and Tricor to work with the inmates that will be released within 3 to 6 months, that are pending 3 to 6 months release, to train them on car buying tips. What some people do not realize about that particular population or that particular program is that those individuals have gone through an extensive rehabilitation program. They also have a savings account while they're incarcerated. And some of the barriers to success after release is, of the top 3, is a failure to have transportation. And so I will be working with them, or they're sending money home to their families, because some of those programs are living wage programs. And so they're sending money home to their families to help purchase cars. So I will be working with those groups. My first teaching engagement is in about 2 weeks. It will be in Nashville, and then I will be going to Mark Luttrell in Memphis to help teach some of those individuals on what they need to look for. They have incorporated this as part of their financial planning classes so that they'll be prepared when they are post-release, so they'll have a greater likelihood of success. I've also worked with the county clerks to distribute the video so they can be presented in their offices. and communicated with Department of Revenue and Department of Safety in order to have some of the videos played in their public receiving areas to help reach the public. So we're really focusing on educating the public in an attempt to reach those high-risk consumers. We are taking a strong focus at all aspects on advertising and teaching the consumers on what to look for in the advertising. So that may result in increased complaints going forward in the advertising area.
Questions for Director Shaw? Very good report, and, did I hear someone? Okay, right. Very good report, and the metrics are, of course, outstanding, and the 99.1%. And then the proactive work toward educating the buyers is a great effort, and we hope that will be productive as it sounds. So thank you for that. Okay, no further questions. We would need to get a motion to adopt the director's report.
Commissioner Jackson, motion to adopt the director's report.
Second.
Commissioner Jackson, motion to adopt the director's report, seconded by Commissioner Vaughn. Any comments on the motion, discussion of the motion, concerns about the motions? Chair hears none. By voice vote, those in favor of the motion to adopt the director's report would say aye.
Aye.
Those opposed would say nay. Motion carries. Thank you. Paige, are you doing the legal report? Or Commissioner Jackson, we're ready for your legal report. And then you.
And again, it's Commissioner Jackson. We had numerous discussions on a lot of cases, but the most important case was about the flooding of cars in Houston, and I'm going to get Attorney.
Morning, members of the commission. Yes, Commissioner Jackson is right. We've had I think we've all been preparing to hear of flood vehicles, and we finally have. We were made aware of an issue coming out of West Tennessee where vehicles were being sold out of a unlicensed in the sense of our board, flea market. The vehicles were being sold on original MSOs. They are, for all intents and purposes, when you look at the paperwork and at the vehicle, they appear to be new vehicles. Investigations between ourselves, our team here, as well as Texas, has revealed that these vehicles were originally at a dealership in Houston during the original flooding from the hurricane. All those vehicles were part of an insurance claim itemized in the list, and that dealer in Texas was paid for them. The allegation is the Texas dealer was asked by the adjuster for a subcontracted insurance company to produce the titling documents open to them, and the dealer did so. So 32 vehicles that we know of have eventually, through the insurance companies, made its way to Tennessee. And the flea market operates also as a salvage company. Asked by insurance companies to sell these vehicles on their behalf. Ultimately, the salvage company didn't quite know that process, learned from the county clerks you have to be a licensed dealer, and ultimately, due to an inquiry from a dealer, was partnered with a dealer, one of our licensees, in order to move this inventory in the state of Tennessee to consumers. The dealer did create a disclosure form indicating the potential history of the vehicle, but obviously, as you all know, any consumers after that will not be on any notice. These vehicles are being sold on original MSOs and being titled with original titles in the state of Tennessee through our licensed dealer. We are working extensively with Texas and with our internal insurance team, who have been fantastic, to try to ascertain not only what comes before this commission, what authority do we have to discipline the flea market, the insurance companies, and our licensee, but in addition to that, what potential implications are there for the insurance company as far as their insurance license goes in the state of Tennessee, as well as Texas, or wherever they may be. So we're still deep in investigation into that element. Obviously, as you can imagine, we're dealing with some sophisticated entities in an area that I'm not as familiar with. So I'm doing a lot of deference to people who know a lot more than me in insurance. But it's been an interesting ride, and it's been wonderful to see Texas take a lot of ownership and understanding of the implications of what happened in Houston and what that means for the surrounding states. You can tell Texas takes this very seriously, and they've been very open with us and sharing everything they possibly can. So at this time on the legal report, I apologize, I'm trying to remember which number I had it on. 48. Thank you so much, Commissioners. Number 48, at this point, you'll see we have asked for a $5,000 civil penalty for unlicensed sales activity against the flea market and $5,000 for off-site sales and allowing basically the flea market to act as an unlicensed salesperson for a licensed dealer. I anticipate you may see follow-up reports in the future related to either other entities, perhaps these same entities, as we start to ascertain more of the information. Chairman Roberts made a wonderful point that possibly even the insurance company, depending on their role in the sales. But this is an active and ongoing investigation between us and Texas. So it's taking a little time to do the interstate cooperation, but it's been a good process. So definitely, keep an eye out there. I have to give compliments directly to staff. Our team here has already put out extensive information to consumers about flood vehicles, what to look for, the dangers. And our hope is to work with Texas to figure out how should these vehicles have been titled and what do we need to do with them now so that consumers in the future will know where these vehicles came from and what potentially could be wrong. Texas at this point has not issued a formal opinion on what the title status should be, but they are working on that actively now. And they've kept me in the loop pretty much bi-weekly. So when we get an answer to that, I'll be able to let you know what we're going to do here on our end as well. So if anyone has any questions about that, feel free to let me know. If you have heard about this incident, it's kind of been a little public, please, at any point, feel free, if you don't feel like you can be impartial, to recuse yourself from the vote on that portion of the legal report. But otherwise, at this point, this is just our first wave of action. So,
Also, for your information, the staff has about 32 cars that they are aware of that done flooded into Tennessee at this point. Any other comments, Chairman Roberts? Any comments? Any other commissioners? With that said and done, I make a motion that we adopt the legal report as explained on case number 48.
Motion to adopt, Commissioner Jackson, seconded. Commissioner Vaughn. Any comments or questions on the motion? Do we need a roll call vote? No. Okay. We usually do. Didn't on the last on the last report, director's report, but maybe the legal report, maybe we do. I'm going to err on the side of caution and ask for a roll call vote on the motion. The motion is to adopt the legal report with the amendments noted by council.
Members, we also have a addendum. There's one case on that addendum, if you would include that also.
All right, let's
Okay, that was case number 20170618881. That include also, I like to amend my motion that we include that case also.
Agreed.
an amendment to the original motion, adding in the representations. Action noted and agreed to and seconded by Commissioner Vaughn. Okay, roll call vote on the motion. Yes will be to adopt with the council page. Ms. Shaw.
Commissioner Levy? Yes. Clayton?
Yes.
Commissioner White?
Yes.
Commissioner Murray?
Yes.
Commissioner Tribanian?
Yes.
Commissioner Lee?
Yes.
Parker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
Yes.
Commissioner Norton?
Yes.
Commissioner Vaughn?
Yes.
Commissioner Jackson?
Yes.
Commissioner Evans?
Yes.
Commissioner Tomaso?
Yes.
Chairman Roberts?
Yes.
Motion carries.
Thank you, Commissioner Jackson. Sarah. Legislative updates, Assistant General Counsel Elizabeth Goldstein.
Mr. Chair, I do apologize, but I did speak with my supervisor about the new Fresh Start steps, and I will actually need to, I know that the commission did vote to adopt my analysis in the memo, but I will actually need to read that onto the record and then ask if you would do a new vote. I do apologize. This is a new process, and I just want to make sure we're following it closely. So if you'll give me just a few minutes to read through my analysis on the record, and if we could have the commission do a new vote for the appeal. Thank you. This is in regards to the application for Mr. Kevin Ortiz, and our office has reviewed the application submitted by Mr. Ortiz, which included a criminal conviction. The relevant statute for determining whether the commission has the discretion to deny this application on such a conviction is found in Tennessee Code Annotated 5517-114A1C and also the new Fresh Start Act. Mr. Ortiz's conviction was FSA 812.014, grand theft in the third degree from Miami, Florida. The date of his release from probation or parole was December 2014. 5 years from that date would be December 2019. So based on the analysis provided above, the applicant's conviction does constitute a crime involving moral turpitude, and further, 5 years has not passed since the latest date of release of probation or parole. This applicant's conviction of moral turpitude involving a crime of theft, grand theft, may be seen to directly relate to the applicant's fitness to practice within the occupation applied for, because it is a crime involving theft, and theft involves a knowingly taking the property of another with the intent to either deprive or appropriate the property for one's own use. In this case, the grand theft may be seen to directly relate to the applicant's fitness to be a motor vehicle salesperson, because the applicant would have open access to the customer's financial information and personal identifying information. This individual is convicted of crimes including grand theft. This crime's seriousness is significant because it involves theft or knowingly obtaining or using the property of another with the intent to deprive the individual or to appropriate the property for one's own use. The length of time since the commission of this crime is 7.5 years. The regulated profession involves the advertisement, sale, and or distribution of motor vehicles and or recreational vehicles within the state of Tennessee. Such profession involves the interaction with consumers that generally would constitute a significant monetary purchase. Persons licensed in such profession would be in a position requiring honesty and trustworthiness in order to curb misrepresentations, fraud, or impositions upon a consumer. Generally, consumers are less sophisticated than those within the regulated profession, and as such are susceptible to harm and in need of certain minimal protections, including the evaluation of honesty and trustworthiness of those regulated within the profession. Further, such licensee would generally have access to the individual's personally identifiable information. The relevant criminal conviction indicated previously of grand theft does have a strong relationship with the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of someone within the applied profession. This person's conviction proposes a significant threat to the discharge of the duties within the profession because their past conviction shows a lack of concern for another's property. This applicant has not provided evidence of rehabilitation. Based upon the analysis provided above, it is my opinion that the Commission likely does have the discretion to deny such applicant based on his conviction of moral turpitude under the analysis required by the Fresh Start Act.
While this has some explanation of Fresh Start Act, this information is specific to the applicant for which the Commission voted to uphold the denial previously. Is that okay?
Yes, sir, that's correct.
Okay. We already have a motion that carried. It can't just go away. My suggestion is consider this additional information and to not vote on this unless we want to repeal. Is there anyone that disagrees with that? That's it's the commission's made a decision. Unless I see some consensus that we need to talk about repealing the other, or I think we need to let it. Thank you for that information.
Next, I will ask that in response to these appeals and denials, the Commission will be sending out letters to the applicants that inform them of their right to appeal within Chancery Court. I'm going to read the suggested language from our Deputy General Counsel, and if the Commission would vote to adopt that language so we can move forward in utilizing it in our letters. The language would be as follows. The Motor Vehicle Commission on blank date decided to take action as a result, and right there we would put uphold the denial, or we would put approve the application. As a result of your conviction on or about the date for the offense, the Motor Vehicle Commission has decided to take this action after considering the following factors as set forth by the Fresh Start Act, and then we would place the factors there. If you wish to contest this determination, you may file a petition within 30 business days of the receipt of this notice in Davidson County Chancery Court, at which time the Commission must demonstrate by a preponderance of the evidence that the individual applicant, licensee, or certificate holder or registrant's conviction is related to the applicable occupation, profession, business, or trade. I apologize. One last sentence. For initial licensure denials only, you may reapply for licensure immediately.
Questions? Is there a motion?
So moved.
Okay. Motion to adopt, Commissioner Barker, seconded by Commissioner Chobani. Any discussion of that motion? Hearing none, we'll do this by voice vote. Those in favor of the motion to adopt the legislative update report, say aye.
Aye.
Those opposed, say no. Motion carries. Committee reports. Clayton, do you wish to report anything other than that we met on June 13? There was some information already in the director's report regarding the.
Right. The committees actually met in June of this year. The audit committee met on June 13th, 2018, and additional information will be coming in regard when we receive the closeout numbers, and after the committees reviewed it the following time, it'll be presented in October with the closeout financials and the financials for the new budget year.
I think in your report, there was a current the fiscal year to date deficit of 152. Okay. Which that's tracking toward our expectations. We had a small surplus. Comments, Chairman Clayton, on the
year-end numbers will be computed when?
The state calendar year closes on June the 30th, but it takes a period of time for the state fiscal to compile all of the numbers with the closeout of the book. So generally, we see those numbers late August, September, something along those lines. So we should be prepared to have another meeting with the fiscal committee somewhere early fall, late summer, to show the closeout, and also at that time we should have the information for the new budget year.
Ms. Shaw, would you put that on the agenda for October financial? There, by voice vote, is there a motion? I'm sorry. Is there a motion to approve the financial report?
Oh, you're going to, go ahead.
I'm looking to close out the financial report.
Yes, go ahead.
So I'm looking for, if there's a motion to adopt or action seconded. By voice vote, those in favor of the motion to adopt the audit committee report, say aye. Aye. Those opposed, say no. The rules committee met June 13th. I think you had a general.
Since I don't have any notes in front of me, I'd like to turn it over to the staff for any kind of update for the Rules Committee.
The Rules Committee also met June 13th, and there were some suggestions that came from that meeting, and language is in the process of being drafted in a red line. I don't think we're prepared to go over those red line drafts at this time. It needs to go back to the committee before it actually comes to the full commission. It's not uncommon for something to go to committee a couple of times before it ever makes it out, so that those discussions are thoroughly vetted. But legal has been diligent in a red line draft to this point, and likewise with the audit committee, we should be meeting again. That committee should be meeting again late summer, early fall, and then we should be able to present those things at the October meeting as well.
I'd like to add to that report that there was public comment that was allowed at the Rules Committee meeting.
That is correct, and those meetings were all publicly announced, and minutes were kept. All met the Open Records Act.
Prior to our next Rules Committee meeting, we will send out the draft red line to all committee members. So if you have feedback you want to send us prior to the meeting, we can edit the draft before the committee discusses finalizing it, and then we would, like Ms. Shaw said, move it in front of the full commission for discussion.
Questions or comments on the Rules Committee report? Hearing adopt the Rule Committee report.
So moved.
Motion, Commissioner Vaughn, seconded. Commissioner Clayton. Comments on the motion? Hearing none, by voice vote, those in favor of the motion to adopt the Rules Committee report, say aye.
Aye.
Those opposed, say no. Motion carries. Thank you. Okay. Director Shaw, anything under new business other than our meeting tomorrow?
The only new business that we have is a proposed agenda for the 2019 commission meeting dates. If you take a moment to look at those. We did try to break out and specify in this, we're trying, continual process improvement. We did try to focus on identifying the committee dates by committee type going forward. In the past, we have just identified dates and said committee, which has created some confusion. So hopefully this will allow the committee members and the commission members to schedule more timely.
Only question I have is April 21st is Easter Sunday.
Alternative.
Quarterly meetings. I guess there's not really one, but we've done the last 2 years. We've missed it. Option, or is we pretty much, that's it?
I had to look to check.
We've
on
missed
that.
it the last 2 years, which has been great. I mean, I'm used to it because we did it for years, so it was always Easter Sunday. I had salmon every Easter Sunday.
Would it be helpful if we just met on, would it be helpful if we met on Tuesday?
If the commission is
Drop the Monday.
open to that. The only challenge that I see, but I think we're far enough ahead, is that second date on the quarterly committee meetings. The first date is usually the commission meeting. The second date is usually held for formal hearings if we have a formal hearing. And the only concern that I'd need to refer to legal for is to see if that would be a conflict in holding that second date for any formal hearing in the month of April with the ALJ.
We would provide those dates to the ALJ, and they would schedule those. So
Okay, great.
there should not be any problem with that.
If it's a big problem to move that around, then
April 23rd and 24th work. Could be later in the week. It would be away from what you're used to on Mondays, but
Just ask if that's available. 23rd and 24th are available, or are you going to get back to us? Do we know?
at this point, what we're trying to do is get ahead of all of the other boards who try to schedule this room and all of the other boards who try to schedule the ALJ. So the sooner we approve our dates, the sooner we can get the dates that we would prefer.
Good reminder.
Oh, we'll remind you.
I'll probably still drive up here on
Some
Sunday.
of us are kind of hooked into Mondays.
As the need to establish quorum intensifies, you will be reminded, I assure you.
I don't know how I can live without a meeting, without a Monday meeting.
Well, on a similar issue, the January 22nd meeting is the day after Martin Luther King Day, so it looks like it's scheduled for Tuesday. Someone just holiday travel, being out of the office an additional day anyway. There's too much to change it now, but in the future to avoid.
School holiday.
We actually looked at a middle of the week. We discussed moving the commission meetings to middle of the week because of things like that before, but that's not been an interest that the commission has expressed in the past, but we're open to that.
We're moving it to the week before, or week after, similar.
My suggestion would be, if we're in looking at the Martin Luther King Day change and Easter holiday,
Okay, so would you like for us to look at, you want us to look at the Tuesday, Thursday, all the way through? Tuesday, Wednesday? Excuse me.
if I'm going to change two, I'd rather just change them all. It'd be a little easier to administer and remember for.
Conflict with that?
No, ma'am.
I'd rather not change anything. You can start.
I'm not going to sit between you two guys.
It's already set. Just go with it.
No, it's not set. No, nothing is set. I was making suggestions for a motion. And I want to change two, I'd rather just change four and change them to the middle of the week and be consistent that way. And that would be a motion that I would suggest someone make, and then if full schedule, so we could have, we don't need 7 different motions. I'm trying to condense them down into 2.
I'll be happy to make a motion.
Could I ask a question first?
Sure.
Thank you. I've heard a couple of the commissioners talking about where we have these hearings like we do tomorrow. Why could those not be scheduled for the afternoon of our normal meeting so that we're not taking everybody's 2 days where we could do the work in 1 day? And I think you'd find that it'd be, the commissioners would be willing to do that instead of having to spend 2 days. I mean, as today, we're going to have a clear calendar for the afternoon. If you scheduled morning, scheduled afternoon for the hearings, you're not taking 1 day away from your jobs. It makes more sense to me, and it's more economical for the commission to do it that way.
It does make logical sense, I agree. The challenge that we have is the length of time of the actual commission meeting itself, which was likely to be shortened with the appeals, but we don't ever know how long it's going to be. And the second thing is we're behind. We have to deal with the ALJ schedule and what they can accommodate, and whether or not they are willing to be present if your meeting starts at 2 o'clock and it runs to 9 o'clock that night, which we have. Some of the other commissions and boards have had that experience. It usually doesn't go over very well.
That was the thing I was going to add, is that sometimes the hearings can be an hour or 2, sometimes they can be 10 hours. So if we're having the commission meeting in the morning and not starting the hearing until later, we can't guarantee what time it's going to end for you getting back. That might cause a lot of trouble with travel.
Well, as it is now, we have it scheduled for 2 days. Couldn't we schedule it to begin in the afternoon, still keep that second day scheduled if necessary, find a reasonable time to stop on the back? That way we're not asking for anything additional. We're, I think, just creating a possibility of eliminating a day.
Yes, that would be possible. However, you have to keep in mind that we would have to then schedule the administrative law judge for possibly 2 days. We could make that request to have hearings begin at 1 p.m. the day of a board meeting. However, we'd have to check with them if that's possible to start the hearings at 1 o'clock. And if there aren't any, or if there's a short one, we would conclude by 5, or if there was a long one, we would begin it at 1 and then adjourn at 5 and then reconvene in the morning the following day. We just have to check on their availability.
We could leave that up to the discretion of the staff. If you feel like it's something that might work, then it would be great. But if not, I mean, people that have been on the commission for a long time, we've been here sometimes all day, and you talk about a long day. And that wasn't even with one of those cases.
But I agree. For
I left here at
efficiency, it
7:30.
seems logical, because we even discussed that this time, and because this is a short meeting, and tomorrow's hearing is likely to be relatively short as well, and we looked at that possibility, but we have an external group that we have to coordinate with as well, and that's where part of our challenge comes in.
I'm in great sympathy with the consolidation into as few days as possible. From experience with formal hearings, there are formal hearings and there are formal hearings. Formal hearings can get very one in a while, but half dozen very, very important decisions for both the parties, and the ALJs. Once you have an ALJ, they will not let us shortcut anything. You got to go. We have to go through all the paces. Now, my sympathy is with Commissioner Lee's thought about it for years, how to get there. I guess that the best we could do in regard to that idea today would be to not have a vote, and the chair would charge the staff with doing a feasibility conversation with ALJs and voting on this in October.
May I make a suggestion? Knowing how quickly the calendars for this room fills up and how quickly the ALJ calendar fills up for the upcoming year, at least for your commission meetings, I would move forward as quickly as possible, or we'll end up meeting in a tiny little room upstairs with a video recorder. And it gets really challenging. It really gets challenging, especially when you have a 17-member board.
That's exactly right. I agree with that. I think we...
Or we could consider moving, we historically have put the hearing dates back to back with the commission meeting dates so that you didn't have to travel twice. We could separate those. You meet 4 times a year. Would it be of benefit to consider separating the ALJ dates, like you're meeting January, April, July, October? Would it be easier for you all to look at meeting, say, February and May, where you're coming in more often, but you are likely to be here one day at a time, and if it's a long hearing, you're not back-to-back with a full day of commission meeting before? Those are options that we have. But as far as the quarterly meetings, I would not hesitate on securing my dates.
Now, we could go ahead and schedule 2 days, one for the possibility of a formal hearing, and then I guess we could go back and change those dates if we get some favorable report, excuse me, about piggybacking these, a formal hearing on depends on the urgency
Possibly
of getting
hold
room.
a couple extra hearing dates in the off months, so that if it looked like we needed to move, go ahead and schedule these dates, and then if it looked like there was going to be a great conflict, we could hold, I'm going to say, a couple more hearing dates throughout the year in the off months that might require that you come in one of the months that you normally would not.
I like that idea.
Problem with that?
We would just have to provide those dates to the ALJs, and we could always, you could adopt the two dates back to back, and we could check to make sure that there are ALJs available to begin at 1 p.m. on the day of your board meeting, as well as the following day, and we could report back and let you know. Or if you wanted to select additional days on the off months, that's also an option. We just need to provide these dates to the Secretary of State's office, Administrative Division, for them to schedule the dates.
I have one comment on that. With 8 of 12 months being scheduled for meetings, you're probably going to have to take a longer look at availability rather than the week before or 2 weeks before, because the chances of between business and personal travel that you're going to have. I can tell you right now, I'll miss 2 meetings a year if that's the way it's handled. 8 of 12 months. If you're asking me 90 days out, then I can schedule around that.
I'll restate that scenario.
I understand this correctly.
Well, I got a few head nods on that one.
We would move, we would shift the commission meeting dates from the quarterly dates to the Tuesday, Thursday dates immediately following, like January 22nd, 23rd would be 23rd, 24th. Tuesday, Wednesday, so we could go ahead and do that. And we could also look at identifying 2 additional hearing dates that could be used in the off months as I'm going to say a fail-safe for those situations where maybe we had an extremely long commission meeting and it didn't seem feasible to carry forward with a large, a lengthy hearing that we might have. And I know we also discussed, and I think legal can check, with if we shift it with the 4 known or 6 known dates, they can see what the availability is on the preceding day on the 4 quarterly, just in case there happens to be another ALJ available at that point in time if we finished up on a commission meeting date early.
We're going to pick out 4 Tuesdays and 4 Wednesdays for a quarterly meeting.
Safe. So basically, we'd have 6 dates held for formal hearings, where now we have 4, and that would give us some flexibility. Does that work?
Well, I like that because there are some wide variations in the formal hearings. Tomorrow should be a short one, but some of these things, if you come in and you piggyback with a regular meeting, you're here. We might be here if we don't have the room the next day. We might. Some of them can be a pretty good grind, not to scare anybody off, but.
I'm hearing that by this, we're going to give ourselves flexibility. If it's far enough out and we can schedule one at 1 o'clock on a hearing date, then we'll do that. And if not, we're going to have after still scheduled or one of these other 2 additional hearing dates.
ALJ's office is available on those dates. That's all. We all have a dependency there.
We can go ahead and approve the dates as suggested with the shift to Tuesday, Wednesday for the 4 proposed dates. Get the request in for the room
The
now.
staff to identify 2 other days, or do you know what those days
We
are?
will work with legal to see if we can work with the ALJ's office, because for that to be successful, we need to coordinate with them to identify that.
Back to us in another report.
That's correct.
Okay, so right now we're breaking it down into what I recommends, and I think we're getting toward is 4 Tuesdays and 4 Wednesdays out of the calendar year, and then we're the staff to look into 2 more dates for a formal hearing, standalone formal hearing. Look at a calendar and let's be date specific while we're doing these.
All of these proposed dates are Monday, Tuesday dates. They are. Or Tuesday.
It should be Monday, Tuesday.
January 22nd, 23rd is Tuesday, Wednesday, because that's
Taking into consideration the holiday.
I think we would propose suggesting a 1-day shift for the April, July, and October days. Actually, just a 1-day shift for all of them. But that does make January a Wednesday, Thursday. April's a Tuesday, Wednesday, July is a Tuesday, Wednesday, October is a Tuesday, Wednesday. Just one day. And those proposed
Like
dates
for
would
it to
be
be
okay.
date specific in the motion.
Correct. Can I try to construct that? I propose that we, okay, I make a motion that the quarterly meeting dates be January 23rd and 24th, April 23rd and 24th, July 23rd and 24th, and October 22nd and 23rd. January 23rd and 24th, April 23rd and 24th, July 23rd and 24th, and October 22nd and 23rd.
Well, if we know what they are, however, I think getting a consensus on
Find what the ALJ availability is first, then have that proposed to us.
why don't we see if we can get this motion done, get this part done, and then I will instruct the
I'd like to second the motion.
We need to read at the end. Did everyone get the motion? Okay. All right. Okay. We won't beat it to death. Those in favor of the motion of the dates read into the record by Director Shaw, motion, say aye.
Aye.
Those opposed, say no. Chair instructs the staff to bring us options for 2 more standalone formal hearing dates in the calendar year 2019. Old business. Okay. Anybody know of anything I missed or need to cover? Hope not. Okay.
Got something. I don't know if it's old business or new business, but if I may, in the notification of statutory changes, is this now the time to address one of the statutory changes?
Let me ask you, is this old business?
On our notice of statutory changes.
Oh, notice of statutory.
Stein, can you
Has
read
that been circulated or?
Yes, we circulated it to the commission members, and it was also sent out by electronic notification to all of our licensees. I didn't want to be redundant and read it all into the record since you'd all previously received it, but I would be happy to read our short summaries.
Was it read into the record previously at a previous meeting? Seems like it was.
I can't remember, so I'm happy to read it into the record now if you'd like, just to be safe. Okay. We have a few different bills that were approved into law this year that affect our board. The first one is Public Chapter 0668, and the brief synopsis of that is this act authorizes the Motor Vehicle Commission to take licensure action against a dealer who fails to maintain a record of a customer's motor vehicle liability insurance coverage or other proof of financial responsibility for any customer who is issued a temporary plate by the dealer who also finances the sale of used motor vehicles and retains titles to such vehicles. This act also requires the record to be maintained in the same manner or period of time as the record of issuance of temporary plates. And for the purposes of rulemaking, this was effective April 12th, 2018, but for all other purposes, this will affect the dealerships in January 1st, 2019. Our second public chapter that affects us, we did go over this a few times at this meeting, is Public Chapter 0793, and that's the Fresh Start Act. The Fresh Start Act requires that certain state departments, boards, commissions, or agencies not deny an application for a license, certificate, or registration or refuse to renew a license due to a prior criminal conviction unless the conviction directly relates to the applicable profession. This act sets out notification requirements for the agencies that intend to use a conviction as the basis for a denial of licensure, factors that must be considered in determining whether to deny or refuse to renew the license on the basis of a criminal conviction, sets out that certain crimes create a rebuttable presumption of being related to the profession, provides information that must be contained in the notice of determination by the agency, and provides that a decision under the Act may be appealed to the Davidson County Chancery Court within 30 business days of receipt of the notice of a denial or refusal to renew. A potential applicant may also request a pre-application determination from the agency as to if a conviction will prevent the person from becoming licensed. That's effective July 1st, 2018. The third is Public Chapter 1021. This act sets out that the venue for appeals of contested case hearings, except for hearings involving TennCare appeals, shall be in the Chancery Court nearest to the place of residence of the person contesting the agency action, or alternatively at the person's discretion in the Chancery Court nearest to the place where the cause of action arose, or in the Chancery Court of Davidson County, effective July 1st, 2018. And our last public chapter that affects this board is Public Chapter 0519. This act requires all agencies holding a public rulemaking hearing to make copies of the proposed changes available in a red line format. That's for people attending the hearing, July 1st, effective July 1st, 2018.
I think any action is required on that.
On Public Chapter 0668 regarding the motor vehicle liability insurance coverage, my question is responsibility of the commission. How will that be monitored? How will that be audited? Because it's going to affect us as a commission. It will affect us as dealers too, because this is new. It was new to me until I saw you sent your electronic version of this out. I mean, how does this work? I mean, it shows, it says that a dealer who finances, but it also requires the record to be maintained in the same manner of period of time as the record of issuance of temporary plates. So that's going to require a physical record of liability or insurance to be maintained by a dealer in his dealership. How will that work?
Norton, and it's important to clarify that this just applies to the buy here, pay here, and only during that period of time where you have a temporary plate on the vehicle, and you would keep it in the same manner that you would keep your temporary tag. So once that temporary tag is expired, you have no obligation, or the buy here, pay here would have no obligation beyond that point. It's my understanding that this legislation resulted from a very tragic incident where there was a tragedy during that window of time, where there was a concern about what the coverage actually was. But it would be, to answer your question about how this would be monitored and checked, it would just become part of the inspection process that they would look to see on the inspection sheet that you actually, if it was a vehicle that had been financed with on-lot financing, that there was documentation or information to show that there was proof of insurance during that period of time. Just another process, another step in the process. Does that answer your question?
Yes, it did. Thank you. And I think it's a good bill too. Thank you.
Y'all tell us a little more about the meeting in the morning, time, et cetera.
I'm going to yield to legal since that is their.
Let us.
Miss Page has stepped out of the room.
Just the time and so forth.
Commission members, I believe that this hearing is going to be conducted by Sarah Page, and it begins at 9 a.m. It's been noticed for 9 a.m., and there will be an ALJ here for that.
This room?
Yes, sir.
Okay. Any questions? And your chair failed to take into consideration the 90-degree rule. I guess that's because I bought a necktie and I wanted to wear it, so I didn't think about it. Had a narcissistic moment. But tomorrow's a formal hearing. The chair would appreciate business attire tomorrow. No requirements, but I stepped on somebody's toes pretty hard. It was okay. All right. Business attire tomorrow, please. Anything else before the commission? The chair would entertain a motion to adjourn.
So moved.
Those in favor of the motion to adjourn, say aye. Aye. Those opposed, say no. Thank you, everyone, for your attendance.